The broadcast is now starting. All attendees are in listen-only mode.
Good morning, everybody. Good afternoon, wherever you are. Mike Volkov here, and we're here for the new FCPA enforcement and compliance strategy. I downloaded or uploaded the slides, and if you should be able to download them. Sometimes people have trouble with that. If you want a copy of the slides, just send me an email at mvolkov@volkovlaw.com, which is right on the first page there. mvolkov@volkovlaw.com. And hold on one second. And I'll send you a copy of the slides. I'm just fixing the screen. Okay, and feel free to ask questions as we go along. It's great to see everybody. Thank you for signing up for this. The FCPA still carries a lot of headlines, and feel free to ask questions as we go along. I try to answer those as we go along because we get some really good questions usually. This is, again, every time the FCPA comes up, it turns into, an interesting issue, interesting webinar, pretty good turnout for these as well. Just a quick marketing, hit here. Just remember, we are available to help you. Policies, program assessments. We're doing a lot of work lately, not in the anti-corruption area, but really in the trade compliance area. That is sort of the hot issue, and we're going to talk about that. And we've also been doing a lot of work in post-acquisition integration planning and audits. But we have a long history with third-party risk, policies, procedures, and training. Anytime you need training, we're here to help and to promote ethics compliance. So what we're going to talk about today is, sort of how we got here with a quick review of the pause, the new guidance that was issued, sort of the resumption and what it means of FCPA enforcement, the sort of change in the guidance and the enforcement principles. Some new principles were injected into this, but there also was citation to a lot of the older principles as well. So this is our agenda for today. Again, if you do want to get a copy of the slides, you can't download them. Just please feel free to write me at mvolkov@volkovlaw.com, my email address, and we'll get them to you at the end. So here we are again. It's kind of like, deja vu all over again. We went through a process that was kind of like 2010, just to show my age, where FCPA became a hot button issue, and there were political forces that were pushing, the Chamber of Commerce were pushing, and then there was an attempt to sort of provide more transparency and to rebut the political arguments against the FCPA. Well, with the new administration, the Trump administration, remember, we had a little bit of a track history in terms of FCPA enforcement. Before the first Trump administration, everybody cited the fact that President Trump had called the FCPA a horrible law. And during the first Trump administration, 2016 to 2020, we expected to see either dismantling or a step back from enforcement. And instead, what happened was it was perhaps, and I'll show you the statistics for it, it's kind of interesting, that during 2016 to 2020, or during the time of the Trump administration, 2017 formally, it was a pretty significant period of enforcement with even the imposition of corporate monitors and increased prosecution of individuals. So Um, that's just the history. So when President Trump won again, nobody was expecting the pause. I think they were expecting just a resumption of what happened between 2016 and 2020. Instead, we got soon, in the beginning of the administration with the new executive orders coming out, there was a pause to FCPA enforcement. New DOJ guidance was supposed to come out in 180 days. DOJ and then the SEC has followed suit, have reviewed and dismissed certain cases, and other cases have continued forward. And the dismissal, I think, probably the emblematic dismissal was the criminal prosecutions of the Cognizant CEO and general counsel. And we have a little bit more information on that to talk about that as well. The 2019 Cognizant, it was a pretty interesting case, earned a declination when 2 weeks after learning about a alleged FCPA violation, Cognizant voluntarily disclosed to DOJ, cooperated, and their president and general counsel were eventually indicted on criminal charges. The two cooperating witnesses were the chief operating officer and another executive as well. Those two senior executives pled guilty and cooperated. And then the scheme was pretty basic. It was they were paying a $2 million bribe through a third-party construction company for a permit needed for a new corporate office complex space in India. But this was a pretty interesting and precedent-setting declination. But more importantly, it took 5 years to almost get to trial against the president and general counsel. And on the eve of trial, the Trump administration and the Justice Department dismissed the case. Now, the reaction to the pause on the FCPA enforcement was I think, was a little more muted than everybody expected. I think the UK, France, and Swiss formed an enforcement alliance, but we've really not seen any indication of what that has led to, or something that wouldn't have already occurred. But global companies, not to say it was a yawn, but I would think global companies sort of didn't say, well, let's start dismantling our anti-corruption program. If anything, they just said, we're going to stick with what we do. We don't bribe. We face risks from the UK Bribery Act, SAPN 2, Clean Companies Act in Brazil. So we're not going to really do anything. And there was still the idea of prosecuting foreign officials, and collateral litigation is continuing. But I think, at least from my perspective, this has been the pause, I think, sent a message which I don't think it was the intended message, which was compliance and enforcement are not going to be the same priorities in this administration. I think people interpret it that way, and I think that's a mistake, because I think of trade compliance and other areas that are going to be, and are right now, hot areas for compliance. What I do think is, and we'll talk more about this, is the priority of FCPA enforcement. There's a two-edged sword to it, which we're going to analyze. And it's hard to figure out exactly how this is going to come out, although I have some thoughts on that. So let's look at the time period of 2008 to 2024. And the only reason I want to do this is to show you 2017 through 2020 was the first Trump administration, and look at how those years, particularly 19 and 20, were the most significant years. Now, 20 was an anomaly because it was the end of the Goldman Sachs case, which was in billions. But look at 19. This was, and frankly, there was more enforcement than there was during the Biden administration from 21 to 24. If you see that, there was lot of concern that the Biden administration was going to ramp up enforcement, given the designation of corruption as an anti-corruption as a national security issue. But that really didn't materialize in terms of enforcement actions. And also notice that some of the top 10 corporate FCPA settlements occurred during the first Trump administration: Goldman Sachs, Ericsson, Talaya, MTS, all during that time period. So something to think about in terms of that. Individual criminal prosecutions from 2017 to 2020 increased, but 2019 was the biggest year that ever occurred with regard to individual criminal prosecutions. So that's sort of the context that we're turning towards. And now let's talk about what DOJ's first step was. Right before the new guidance came out, they put out a new corporate enforcement policy. And it's like each administration comes in and has to tinker with the toys and now come up with a corporate enforcement policy. I'm longing for the days when a new administration will come in and just say, we're just going to continue our corporate enforcement policy that's on the books. But each administration has to, tinker with their toys and sort of go after it in that way. The new corporate enforcement program really stressed, again, voluntary disclosure, and now it will result in a declination, not a presumption of a declination. Now that sounds like a lot of mumbo jumbo, but I think the message is clear that basically if you voluntarily disclose and you cooperate and you remediate, you're going to get a declination, and the penalties, I think, are going to be significantly reduced. Now, the interesting issue is that they did not touch the penalty that still must be paid, which is disgorgement. And so that continues, and I think that frankly, a lot of times is the barrier to a voluntary disclosure, that some companies may think, oh, we're going to still have to pay money. And the disgorgement is that you have to pay back whatever ill-gotten gains you had. But there's clearly a decision to refrain from corporate monitors. And as we get to the FCPA program in a second, I'll point out even more. Self-reporting companies are in the declination. Disclosure and cooperation, even after DOJ initiates an investigation, the companies can still earn a non-prosecution agreement and a 75% reduction in penalties, even without disclosure. In other words, and it's just cooperation and remediation, you still would get a 50% reduction and no monitor. So then the monitorships we're not going to see. That's what I just think we're just not going to see them unless some egregious case happens, but I don't think that, I don't anticipate that. What's interesting is as time has gone on, I go back to one of my mentors, Judge Stanley Sporkin, who was famous at the SEC and was an interesting character and considered the grandfather. I call him the grandfather. He was called the father of the FCPA. And he had told me at the SEC what he did was he basically said, if you come in and confess and it was his enforcement policy and you cooperate and you fix the situation, no penalty whatsoever. And in a sense, that's where we're heading. As we see it, they're getting closer and closer to it. You come in, you confess, you cooperate, you remediate, nothing happens. Now, there has to be some purpose to that, and we'll get to that in a minute, because the person left holding the bag are the individuals who can be prosecuted and will be prosecuted. Now, we also saw around the same time as the new corporate enforcement policy was the expansion of the whistleblower program, DOJ's existing whistleblower program, which had been put in the latter part of 2024. And these new priorities were, new areas of interest were added. And that included procurement and federal program fraud, most importantly, trade, tariff, and customs fraud, immigration, sanctions violations, and sort of the continued focus or this administration's focus on foreign terrorist organizations, cartels, and TCOs, transnational criminal organizations. So that was sort of the stage was set. That was the first thing that they wanted to do. In other words, to set up the groundwork for the FCPA and what they're going to do with the FCPA. And the guidance that came out, to be honest with you, was, expected. A lot of it was expected. There were some areas that were not as, that kind of surprised me, and some areas where they just stuck to the old line. So first, let's talk about the purposes that were identified for the new guidance. One is this limiting undue burdens on American companies. And this is a continuing theme about the focus on economic nationalism, but also on the burden that these investigations impose on companies and the reputational damage and the sort of uncertainty that a company experiences. And I think this administration wanted to respond to that. Now, they also wanted to focus the target, like their economic nationalism message, that directly undermines U.S. national interests. And so bribery cases, just for the sake of a bribery case, would not be necessarily within the guidance or within the discretion. But it was to focus again on whether such prosecutions will further the U.S. national interests. And it's very specific in terms of, economic, national security, benefits that are needed for American companies. Now, the focus, like I said, as you start encouraging companies to come in and cooperate, to remediate, and to disclose information, the focus is on individuals who have engaged in criminal misconduct. And that's where they want to look at and continue what I think everybody has been saying for the last, 20 years, is we want to hold individuals accountable. The problem has been, and the guidance even mentions this, that these lengthy investigations have tended to go on too long, and by the time you get to where you're in a position to go after individuals, there's not as much enthusiasm. The other interesting issue, which raises legal issues, is avoid company prosecutions where prosecutors, quote, attribute non-specific malfeasance to corporate structures. In other words, attributing an individual's misconduct and then holding the company liable. They're not as interested in those sort of technical legal niceties, if you want to say it. What they're really interested in is those cases where the, let's say, corporate leaders are involved, know of it, further it, facilitate it. They don't want to see just the attribution rule used as a way to hold a company liable. Now, the law doesn't say that, but the prosecutor's ability to exercise discretion certainly permits this, and we may see some of those kind of situations occurring in the future. The other focus is on obviously expediting these investigations, these 5-year investigations, even longer, some of them, which are definitely not really necessary and can be done in a more expedited fashion. And of course, the collateral consequences and the impact on the U.S. company, like I mentioned before, the undue burdens as well. Now, the interesting, and this is inside baseball, hyper-technical issue, is that first, that the role of DOJ's FCPA unit is, first off, they've lost significant resources, but also their role as sort of the overseer of the FCPA, and that they would partner with AUSAs in the field. Remember, there are 94 districts in the country that have U.S. attorneys' offices with AUSAs in the field with the real responsibility. And I was always partial to that because as an AUSA in DC, I worked for years, on the line, as they said. Now, what happened with this in the hyper-technical issue is one bureaucratic requirement was added, but that was that the Assistant Attorney General for the Criminal Division has to authorize the initiation of the investigation. But what is being done as part of a larger reform effort here is they're freeing the U.S. attorney's offices to bring whatever cases they decide they want to bring, and to go into areas that would otherwise be reserved or overseen or required approvals from DOJ headquarters. Well, that is gone. So now you could have an FCPA case brought by a Houston AUSA with just the initiation of the case by the Assistant Attorney General, and then after that, they run with it. And that is a big change because that opens up the possibility of more resources. And this may be something that AUSAs have always wanted to see a change here, to have more discretion and ability to go after the cases that they want. And I think this is so the two edges here are, one, that there's a cutback in sort of under the guidance as to what kinds of cases should be brought. But there's also been some changes at the FCPA unit in Washington. But nonetheless, you're freeing people in the field to bring cases that they would not have otherwise been authorized to do in the past. So kind of an interesting inside baseball issue. The guidance factors that are cited are promoting U.S. company competitiveness. And we'll get to that in a second, because what this really is getting at, and I think what the Justice Department, as part of its new sort of economic nationalism focus, wants to make sure of, is that U.S. companies aren't suffering and victims of bribery in the competitive marketplace. So, and they also, DOJ cited a true fact, which is that most blatant bribery schemes were committed by foreign companies, not by U.S. companies. I'm not saying U.S. companies are perfect, but I'm saying their record of performance is probably nowhere near as bad as a lot of the foreign companies. And so that raised the specter in DOJ's mind and the new leadership of, you know what, American companies they may lose a tender, they may lose a contract because of bribery, and they're trying to encourage bringing bribery cases where there are specific and identifiable American companies or individuals who suffered, who were victims. And this is an interesting idea. And I've always said over half of the people in jail on FCPA cases were from foreign companies. And that, to me, raises some interesting issues in terms of, if you are and your company is a victim of something like this, you may end up saying, well, let's go in and get the Justice Department to go after these people. And you also may include foreign officials or officials who were taking bribes or whatever. This comes up quite frequently, and people do express frustration over this. Now, they also focused on the need to use the FCPA for advancing national security interests, and specifically identified the industries where there is a national security concerns. So, for example, in the defense industry, if there are concerns with bribery, intelligence industry, and critical infrastructure. And by critical infrastructure, we definitely mean telecommunications, construction projects, and energy as well. So these are now suddenly on the radar. If you come in and you have a problem with, you lose a tender, let's say, and you're in the telecom industry and it had a negative impact on you, this may be something that they would be more interested in because of these guidance factors. So these are the ways to sort of look at what the factors are to go after. Now, the same old song on individuals. There's no question. I mean, this just goes back in time. Prioritizing individual prosecution, go back to the days of the Yates memo and the adjustments to the corporate enforcement policy that I've talked about. And this same theme is going on, and there's a guarantee of a declination, but you got to cooperate and go after the individuals who may have been involved. So that this is really nothing new, and the proof will be in the pudding in terms of what they actually things like that. I've got a great question here, and I want to take a moment just to talk about that. With the new guidance today, what happens to the prior guidance? Emphasis on off-company communication channels use, pilot whistleblowing program. I think all of those things, all of those ideas continue. What I think they called guidance was more on enforcement guidance and not compliance guidance. Now, I have heard rumors that the administration the DOJ is going to take a look at the guidance on corporate compliance programs and try to reduce some of the burdens of that. But I don't know. But for right now, I would still focus on preventing off-company communications. The whistleblower program is still definitely active, and they're committed to that. So we'll have to see, but that's a great question. Thanks for that. One of the new issues, and if you follow my blog, I've been writing about it a lot, and is now this new focus on cartels and TCOs, transnational criminal organizations, and a priority of prosecuting cases where they are involved. Now, I will say it this way. At first, people will just sort of brush over that and say, well, we don't deal with terrorists. We don't deal with transnational criminal organizations. And don't speak so quickly, because I think what this raises for all of us is a new focus, which we'll talk about in our due diligence, in our third-party management. Because what is clear through the years in various geographic areas is that cartels and TCOs may have indirect ownership interests, benefits, and so DOJ is so focused on this issue. If there's an association with a cartel and a TCO, they may be interested in it. In other words, where there's bribes that are paid to cartel members or whatever, that there are ways in which the cartel can become insidious in the organization, in the construction project, or in whatever it is that's being tendered. They can have indirect ownership interests, and one thing that is clear is that they are using more and more, embedding themselves in what look like legitimate business operations, often to money launder or use shell companies associated with their cartels as well. And with links to state-owned enterprises and foreign officials who have received bribes from cartels or TCOs. So, for example, think of a leader who, is sort of a dictator and is receiving bribes from the cartel or the TCOs. These are types of things, to further, let's say, their legitimate business interests. These are kind of cases that the DOJ is going to look at for sure. This is a sort of new hot button issue, and it raises a lot of due diligence issues. Just two examples of this was the Lafarge case, which was not so much an FCPA case, but in 2022, where Lafarge ended up, after paying ISIS and ANF, the al-Nusra Front, they had to pay them to operate a cement plant in Syria, and they paid money to, sort of protection money. And not only for permission to operate, but they also used the ANF and ISIS to um, uh, enact harms or to go after some of their competitors. Really interesting uh, case, and prosecuted in various jurisdictions. But nonetheless, this is something where, this is a case that would clearly be brought. The other one that we talked about in 2021, or well, it actually didn't get settled till much later, was the Ericsson breach of its deferred prosecution agreement, where there were allegations that they had made bribery payments in Iraq to ISIS in connection with to permit the transportation of equipment and other materials needed to construct a telecom cellular network in various locations. So that resulted in a further investigation. There was further issues that came up. I'm not going to go through all of those, but in the end, it was not clear whether or not they confirmed or substantiated the Iraq payments. But nonetheless, this was an issue that came up, and um, I think had a big impact on Ericsson's reputation, and Ericsson fought it very hard for that reason. But these, again, now notice the link with ISIS, and all of a sudden you're going to get DOJ interest. A lot of this goes to your supply chain, which is, the new hot term, mapping and managing your supply chain. But we're always looking for hidden ownership interests. Now, we need to do this for our trade compliance, but we need to do it also for the presence of TCOs, for cartels, for businesses, because what we do not want to be caught with is, wholly aside from the FCPA, is indirectly benefiting cartels and TCOs. In other words, making payments that we should have known were going to, or that were going to be shared by organizations such as cartels and TCOs. So what's the impact of all of this, and where are we going from here? And are we going to see fewer cases, more individuals charged? How, where are we going to go from here? Another question came in. I want to take a moment. What types of due diligence within reason should we focus on to ensure our third parties don't have these types of UBOs, which certainly are unlikely to be found in official ownership records? Great question again. And I think that it makes us a little bit more vigilant, I think, with standard red flags, but indicators of shell companies, indicators of unexplained ownership interests. There may be some follow-ups at the margins that may be required. Also, I think we have to take in geographic risk factors, such as Mexico, certain areas of Asia, certain areas of Africa, and certain areas of Eastern Europe. There's a lot of good material on the web concerning cartels and TCOs, and this is something that is being tracked. And I think we should use that to inform our businesses and where we're operating geographically and the type of business that we're doing. But this is definitely, I think, a newer area for us to integrate into our third-party risk management system. This is not like a major overhaul. What I'm saying is this is something that just has to be taken into account. And there may be cases where you would sort of say somebody's medium risk, But given the presence of certain factors, you may say, you know what, let's find out more about their beneficial ownership. Uh, I think there'll be a small number of entities that will now be higher risk once you take into fact geography, industry, and let's say the presence of certain red flags. In other words, trying to find the UBO for these entities. So it's an interesting area to look at, and I think it's not going to be as big a change as anybody tries to sell you on. But it does mean that it's important to look for various red flags, and particularly in these geographic areas. So, if again, one of the key determinants of how much enforcement is going to occur is resources. And the changes in resources to me means we're not going to have an FCPA enforcement year, at least in the short term, that looks anything like, the last 20 years. What we're going to see, I think, are cases being brought, not as many for a while, for at least a couple of years, until the AUSAs or the agents that want to do the cases suddenly realize that they can go to the district where a company may exist and bring on board those people, as opposed to having a Washington-centric FBI squad or squads that just comes over to DOJ headquarters and meets with the FCPA unit and says, okay, we want to do this case here. So I think it'll take time to adjust on that. The basic resource issue is probably, I hear that the FCPA unit is down to about 18 people, and it's cut in half. A lot of people have been reassigned to trade enforcement or to immigration enforcement. And that's, I think, even though you may have resources, you're not going to have enough to really increase or to even maintain the kinds of cases that FCPA cases have typically done. So there's been a loss of attorneys and reassignment. We've also seen a reassignment of prosecutors to trade enforcement. By that, I mean sanctions, export controls, and tariffs and tariff fraud. We're going to see that. And immigration enforcement. Some of the longtime attorneys at the DOJ's FCPA unit were told to move to the immigration enforcement area. So these resources are reallocated, and I just don't think you're going to see the numbers that are going to match the historical numbers. But that doesn't mean, obviously, what are the Trump era FCPA cases going to look like? And I think there are some forces that are going to come out and sort of, I think, push DOJ to do a little bit more. Most importantly, the competitive harm to U.S. companies from bribery. When somebody loses a big tender or whatever, those companies U.S. companies who have invested and played by the rules are going to be upset and will come in and try to get DOJ to, go against their competitors. There's a way that it can be used effectively as a tool in the marketplace, in the competition, because that once there's a company that's got an investigation going, it's disclosed, it's going to impact the ability of people or the willingness of people to work with them. So there will be a pressure, I think, to produce some new priorities prosecutions. I don't think you're going to see as many increases or even maintaining individual prosecutions unless, because those usually come in the context of corporate prosecutions. But the national security industries, I still think energy will still be a big focus. Telecom has been a big focus. You have Ericsson, the MTS case. And I do think it's going to be with a concentration on foreign companies. And once, if they're able to sort of develop a timeline of expedited investigations and people start to see this, then I think you're going to see this sort of change for sure. Great question came in. Isn't it against the OECD anti-bribery convention to prosecute or not prosecute foreign bribery cases based on economic or political considerations? That's a great question, and it's true. But I would tell you this, that the last meeting, I think, of the OECD anti-bribery working group did not include a U.S. representative. I'm not saying they're going to step out of the treaty or the convention, but I don't think that this DOJ is going to be as mindful as other administrations about the agreements that they've made in their international standing. I just don't think that's going to be a focus for them. But you do raise a good point in terms of that. But the most important, I think when you look at all of this is that, frankly, all of DOJ's cases would satisfy what are, I think, the case size requirements. Okay, so the guidance included language that said that the cases need to involve substantial bribe payments, proven and sophisticated efforts to conceal bribe payments, fraudulent conduct in furtherance of the bribery scheme, and strong indicia of corrupt intent. Well, here's the thing. I can't think of a DOJ case in the last 10 years that would not meet these requirements. There are SEC cases that I think may not meet but that, again, remember, we're talking about the SEC, but from the DOJ perspective, the historical FCPA prosecutions and settlements I think, would satisfy these standards as to case size. Now, whether it was, furthering an economic nationalism message, that's not necessarily true. I don't know. I did not put the cases through that type of standard. But in terms of the new requirements, they also pointed out, don't forget that there's, a facilitation exception to the bribery requirement and the bribery violation. And we've been down that road before. Walmart, for example, argued that all of its payments to the Mexican regulators were just basically to get real estate permits in Mexico was the result, fell within the exception. Well, that didn't last very long. That argument. And I don't think that the argument pointing out the facilitation payments exception is that helpful. What I do think is that they're saying we need substantial bribe payments, plus for the company to be held accountable, there has to be some senior management involvement, awareness, failure to act, that type of thing. And I think most cases by DOJ in the last 10 years would all satisfy that requirement as well. So let's talk about some compliance strategies. What do we do with this new guidance? Do we dismantle our anti-corruption program? No. What do we do? What changes, if any, do we look at in terms of how to operate the program and make sure it's just not sitting there gathering dust? Most companies, and I think this is uniformly true, are not making any significant changes whatsoever. Your culture of ethics and compliance carries an anti-bribery mandate. And there's no reason to relax that, because you may have certain things that you require of people that may be beyond what the law requires as a minimum. And if you were going to relax some of the compliance requirements and start to, incorporate some of these ideas from DOJ, I think you'd lose your audience and it's hyper technical and it would defeat your communications message. The message is we don't engage in bribery anywhere, whether it's with state owned enterprises, the government, or in commercial contexts. The other point is that the companies, global companies, are still subject to pretty meaningful laws like the UK Bribery Act and actually the convention, the OECD convention, SAPID 2 and Clean Companies Act. And there's too much reputational harm that occurs when people are involved in bribery. I think that what the DOJ's ultimate intent here is to, take some of the burden and fear off of some of the large companies with regard to, you're going to be investigated for 5 years. You're going to spend millions of dollars on this. You're going to pay a penalty in the hundreds of millions of dollars. That DOJ was trying to sort of calm down that anxiety, and I think they've done that. They've done that. But remember, we operate with our culture of compliance, and we're not going to undermine that message by saying suddenly, okay, foreign bribery, oh, that's okay now. Nobody is saying let's engage in bribery. Nobody is saying any of that type of thing. And I don't think it would make sense for, after fighting so hard and working so hard to implement a program that is effective, that there's a need to all of a sudden dismantle it. What I do think is there, on the margins, there are going to be certain projects. But I always say, and remember how important culture is, and culture assessments to me are even more important these days, given the varying messages that are coming out from the administration in terms of, one, we're going to cut back on FCPA, but we're going to be super vigilant when it comes to immigration, but even more vigilant when it comes to tariffs and when it comes to sanctions and export controls. So culture in this varying environment and assessing it is really an important aspect of your program, I think. Now, we also have these changes in our risk profile that I've mentioned. We have tariffs, export, and sanctions compliance, which is a priority. Immigration, if you rely upon an immigrant workforce and you have workforce needs, then that's going to be a priority. Anti-corruption messaging and commitment as part of your culture, I think, should continue. But we will see, and would urge you to look at some of your priorities and tasks and make some marginal adjustments. And recognizing also the importance, the continuing importance, even outside the anti-corruption framework, of third-party risk management, particularly with regard to tariffs, exports, and sanctions. The third-party risks are huge with regard to trade enforcement and supply chain management, obviously. Monitoring the marketplace is now suddenly more important because of competitive harms or situations where your company may be hurt by foreign bribery. And so we look at geographic areas, lack of institutional checks and histories, a track record of corruption, and large contracts that are the result of a tender process or other opportunities, a bidding, some kind of process, relationship generated process. And those are things that we have to be careful about. And we need to, if we see things that don't look right that affect us, we need to bring and raise those issues up, because those are potential issues that I think you want to get DOJ involved in. And it's not going to cost you as much, except to cooperate with them, but you're trying to get the government to do your work in a sense. So the factors to weigh while you're looking at this is national security industries, again, competitive harm, proximity in your global footprint to cartels and TCOs, and take a look at the maturity of your program. Your program is probably pretty mature, pretty sophisticated, and maintaining your structure and your communications and other things around this, but adjust the priorities. In other words, move some tasks from from anti-corruption to, let's say, trade. And to me, the cleanest example of that would be, when you do an audit or a sampling, when you look at your what you would do a review of with regard to anti-corruption. Now I would do it on trade, depending upon your international trade business. So those are important things as well. I mentioned adjusting due diligence and third-party risk management. This has to be looked at now from both your distribution channel, because you never know whether or not distributors are, for example, selling to people who have, or to resellers where there may be economic ownership interests that are suspicious with regard to the cartel activity. So you're looking for geographic risks, you're looking for supply chain risks, distribution channel risks, and of course, disguised ownership interests or financial interests in certain business deals, and linkage to cartels and TCOs. For example, an unusual payment arrangement that occurs near the Mexican border is a lot different than an unusual payment arrangement that occurs in Germany, for example. So those things are important to sort of watch over and see where you're going, and adjusting your due diligence again is a worthwhile project. Supply chain audits from both an anti-corruption standpoint and from a trade compliance is now even more important from a trade compliance perspective. And we're seeing with forced labor issues, immigration issues, these supply chain audits are going to become even more important from an operational standpoint as well as a legal and compliance. So remember sourcing from prohibited parties and hidden ownership interests of cartels or financial benefits to cartels or TCOs. And I guess my bottom line message is think about reallocating some of your proactive strategies. I would continue your culture communications, your policy management, gifts, meals, and entertainment supervision. It's rare that there ever was a case that was just based upon GMET. But I think it's worth, adhering to that, particularly because you still face risks from the UK Bribery Act, from France and from other areas as well, and continue training, maybe not as often, but make sure that you still identify this. Where I would reconsider, and what I have been talking about, is adjusting your auditing and monitoring priorities, the slight adjustments that I've mentioned to oversight and monitoring of third-party risk management, and piggybacking on trade compliance activities. There are a lot of trade compliance activities where you can piggyback on it and just, do a compliance check on anti-corruption issues as well. So that's, I see changes at the margins, nothing significant, but smart changes, and make sure it's done in the right way. And always use sampling and data analytics for monitoring and testing. Sampling is the key of sampling when you're going to do a review or an audit in doing that. So those are important issues as well. Okay, any questions? We've sort of come to the end here, and thank you so much. Again, if you want a copy of the slides, just email me at mvolkov@volkovlaw. I'm also going to run my poll if we can help you in any way. Particularly, we're helping people in trade compliance or assessments. Please let me know about that. Um, we will post this. This recorded webinar on Volkov Law YouTube channel, and we obviously have weekly compliance podcasts. Follow our blog, and stay in touch. We're here to help in any way that we can in terms of issues that may come up. We'd love to help you in terms of taking a look at your third-party risk management program. Please make sure you're focusing on third-party risk issues with regard to sanctions. And we're seeing some more sanctions enforcement is ramping up. We had the UNICAT settlement, which is the new model for DOJ, where customs was included in the enforcement resolution, and customs was really important in that case in terms of duties that were evaded. So anyways, thanks again, everybody. Stay in touch. I got one question that came in just now. What do you recommend we do, read, to keep up to date on FCPA compliance directives? Well, my blog, for one, because I'll definitely keep you posted on that. But look for DOJ. I would look for speeches that are given. They usually tell you what they're going to do soon. When they meet with the compliance organizations once a year, they usually have something to tell them, and we'll see what's going to happen. The interesting issue to me is going to be what's going to happen with the guidance that was issued for evaluation of corporate compliance programs. That's going to be the really big issue in my view, because they have to be careful. They want to make some changes to it, and they may see it as, it's accreted too much over the years, and we'll have to see on that. Okay, everybody. Well, thank you so much again. Again, if you need a copy of the slides, just email me, and appreciate it. We'll be back with another webinar shortly, and always enjoy conducting these and hearing from you. Stay in touch, and thanks again.